Would you like to move on to Senate Bill 383?
Yeah, I think we should go ahead and take up Senate Bill 383.
Okay, members, Senate Bill 383 by Senator Duplessis.
Thank you, Chairman and committee. As I look at this committee and I look at my colleagues who were here in 2018, I know at least three, including myself, that would make four of us, were all here back when we passed a pretty significant piece of legislation that called for a constitutional amendment that would move Louisiana away from the awful practice of individuals being able to be convicted by a non-unanimous jury. That was certainly a proud moment for me, given that it was one of the first votes I took in the state house. I served on criminal justice at the time, and I don't think I had been a House member for more than 2 weeks before being able to vote on that. And my previous job prior to being elected was working at the Louisiana Supreme Court, where I was staffed to the Judicial Council, and we were looking at this issue, the fact that Louisiana was an anomaly. And Louisiana was just one of 2 states in the country that had any type of practice like that. And at that time, around 2017 or so, it was sort of a foregone conclusion that we would ever change that law in the Constitution. But, you know, something great happened when organizers and the public decided that enough was enough, and it was time to change that law. And that's why in 2018, when it hit the ballot, it passed overwhelmingly. From all corners of this state, people saw the fact that the law was wrong, it caused a lot of harm, and it's not something that we should stand for. But in doing that, we all realized that the law was only prospective. It was not retroactive. And that there were hundreds of individuals in our state who had been convicted, who were still being incarcerated, who had been convicted by juries that were not unanimous. So we took a position as a state to say that we don't believe this law should stand, and it will only apply going forward. But we didn't take the position to say that all of the individuals who had been convicted of by this unjust law, it's not a question of innocence or guilt. It was a question of the constitutionality and the fairness of the process, and whether or not they received a fair process of being truly found guilty beyond a reasonable doubt. We said that, well, we can't address that. It's either too burdensome, it's going to be too taxing on our system, and we'd rather not address that. I know that there have been attempts over the past several years in the House to try to come up with some type of compromise or some sort of process, working with the DAs, and we have repeatedly failed at that effort to find something that we could agree on that would satisfy both the district attorneys and those who are advocating for a fair process to give these individuals who have been convicted by a non-unanimous jury an opportunity to petition for post-conviction relief. So what this bill will do, it would essentially give those individuals an opportunity for post-conviction relief under the Louisiana Code of Criminal Procedure 930.10. This matter has been litigated. The U.S. Supreme Court has weighed in. The Louisiana Supreme Court has weighed in. This matter is on us. It's going to be on this Louisiana legislature to make the decision as to whether or not we're going to give these 800 individuals an opportunity to petition for post-conviction relief after have been convicted under a process that we have all acknowledged is not a fair process because it was a non-unanimous jury. So that's the simple version of it. I know that there's a lot of testimony here that can speak in much more detail and provide much more of a personal perspective as to why this is something that we should take up. But I thought it was important to bring this bill for several reasons. But I think we should all be asking ourselves if a law we all deem to be unjust and unconstitutional is good enough for us to take off, is bad enough, rather, for us to take off the books going forward, why is it not bad enough for us to deal with it retroactively and deal with those individuals who have been convicted under this unjust law? So that's what the bill will do. It will provide an opportunity for post-conviction relief to apply for it under the Code of Criminal Procedure. And I'm happy to try to answer any questions that the committee may have.
Do have some questions. Senator Kusan.
Thank you, Mr. Chairman. Thank you, Senator Duplessis. And I think I was one of those members who was here in 2018
You were.
through that process. And which member carried the actual constitutional amendment through the
That
legislative
was
process?
Senator Morrell.
Senator J.P. Morrell,
Yeah.
who was in the Capitol the other day, joined us for another bill. He was passionate, and everyone was passionate about the issue and remains passionate, as you can see in the crowd today. You mentioned the constitutionality. Has the constitutionality of unanimous and non-unanimous juries been adjudicated through a final decision at the state Supreme Court or the United States Supreme Court?
The question, my understanding was that the question was around retroactivity and whether or not it would be deemed, whether or not it should be deemed retroactive. And that, I want to say the Ramos case, that's where the U.S. Supreme Court ruled that it did not have to be retroactive. That was the issue that was addressed, as is the state Supreme Court.
So the constitutionality of retroactivity has been determined as constitutional, and the non-retroactivity has been deemed constitutional by, or not overturned by the Supreme Court.
I believe so, yes.
Okay. So now we're looking, this is a public policy decision. You said it's on the legislative branch now, so it's a public policy decision. Okay. What is your standing relative to the cost that the locals might see, our district attorneys who are stretched thin now, who have insufficient funding from the state, and we're dealing with what other means of financing that they have to use to run their offices. They're backed up from misdemeanors to felonies. Could you comment on the cost that we really don't know at this point? And then secondly, and I'll leave it to you because I know you can address all these things. Secondly, and we discussed this going back to 2017, 2018, when we did not have the requirement for a unanimous jury, and prosecutors would essentially rest at a 10-2 type of jury, and with someone being convicted on a 10-2 jury poll, because they didn't have to wait any longer at that time. And maybe there was two people that didn't know what they were going to do. They may have voted with the 10. They may have held out. Either way, it was constitutional. It was the law. And the prosecutors rested on the 10-2 jury to find someone guilty. And now we're saying that we have to go back and look at 800 cases where there was one or two people that we don't know what they would have done had the law been different, and we want to retry it, or we want to give them post-conviction relief. Could you comment on that issue and that aspect as well? Because I think that's really relevant here. And maybe you just want to say, well, we just need to give them a chance because we don't know. But the prosecutors are saying we've already done this under the law, and the victims have already said we've done this under the law. That was in effect at the time. Why should we put everyone back through this exact same process again? So on those two major issues, could you comment, please?
Sure. So from what I'm told and from what I understand is that we're talking around 800 people. And I've seen I think the fiscal note was just provided this morning that says the information that they have, they're using the number 1,500 people, right? But I've been given the number around 800 people. So I don't know specifically what the exact number is, but let's just say it's between 800 and 1,500. But The fiscal note says the amount is going to be indeterminable. But if you do that calculation and you spread that across, I don't know where all parishes it will be out of, so I don't know if it's more in Orleans or East Baton Rouge or Caddo or Calcasieu, wherever they might be spread around. But if we would just do a simple math and divide that up against the 64 parishes, I personally don't think the burden would be that great. I don't think the burden would be that great. I'm not going to minimize it and say that it's not significant, but I don't think it would be insurmountable. I don't think it would break anybody's budget. I don't think it would require DAs to go out and hire multiple prosecutors to look at these cases. It's why we have a post-conviction process. And I know during the special crime session right here in this committee, we debated pretty passionately a bill that would deal with the issue around post-conviction relief. But I don't believe that it would be that taxing. And I think you're going to hear some testimony today that will illustrate why, if there is an additional cost, it's worth it, because there are individuals who were convicted by non-unanimous juries who were not guilty, who were convicted by non-unanimous juries of crimes that never even happened. And I think we have the high burden of a unanimous jury and being convicted beyond a reasonable doubt, because it is that serious, that it should require all members of a jury to agree that they believe beyond a reasonable doubt that the person did it. So we can't speculate that the one or the two who didn't agree, that there was some other reason, or that they may have gone along if they had been there longer and they just wanted to go home. We can't. I don't think that an individual's freedom can be just discarded in that way. And again, this is not about, it is about guilt or innocence, but it's more about ensuring the integrity of our justice system. And if individuals have been convicted by a non-unanimous jury, that's a problem. So there's no dollar figure that's been provided in the fiscal note. We may get one sometime between, at some point. I don't know if we're going to get one, but at this point, I don't think there's a dollar amount we can put on it. But I do appreciate and respect the question.
Two-type verdicts.
Okay, can you repeat that one more time?
The question has to do with, we're going to hear from the prosecutors today that they essentially got guilty verdicts on non-unanimous juries because that was the law at the time. Right. And they didn't have to wait any longer while the jury was deliberating when the jury foreman came out and said, hey, we've got 10, we've got what we need, let's all go home. And so now we're re-adjudicating some of these non-unanimous juries that otherwise could have been unanimous, but that wasn't the law. And so they were found guilty under the law at that time. And so the fact that we didn't go far enough to get the unanimous at that time, the jury could have easily, in some cases, they're going to tell you, we had the unanimous jury, but we didn't have to wait any longer for these last two jurors to figure it out. And you might have testimony today of cases like that. So my question is, philosophically speaking, how does that type of scenario weigh in to why we're going to expend money on a public policy matter to re-adjudicate these cases that were found guilty? And you said there might be some that were actually guilty and the crime didn't happen. But surely there's crimes that did happen and that they were, in fact, guilty. So is that something that we just have to, you're saying that the public policy of the possibility of the innocence outweighs? Absolutely. Yeah, yep. And I think you thank you for, because that's my point. When we talk about the possibility of getting it wrong one time is enough for us to revisit this process, because none of us sitting in this body, none of our family members, friends, I don't think any of us would want to risk or should want to risk anyone's freedom if that person could have potentially been convicted for something that they either didn't do, or there were issues with the trial or issues with the representation. It's why we have the system that we have to ensure fairness, and that's again why we have post-conviction. So I would much rather ensure that we have a system that we would protect that one person, even if it's just one person,
to go back and deal with that, rather than saying, well, it's going to be too burdensome, it's going to be too costly, and maybe those other two would have agreed. They probably did agree, but they got to the 10, they went home. No, from a public policy standpoint, I would not. I can't support that. Yeah, but I understand the
Thank
question.
you. Yeah, appreciate it, Senator. Thank you, Mr. Chairman.
Yeah.
Thank you, Senator Kusan. Senator Bowie.
Thank you, Mr. Chairman. Senator Duplessis, I want to thank you for bringing this bill, because the bill really is about unfinished business.
Right.
This state, the citizens of this state, and Louisiana as a civil society recognize that injustice was done with non-unanimous jurors. And the fact that we said going forward, it applied then, to make it right, we have to deal with the reciprocity, because they are all, we say 800, 1,500, but they are citizens who convicted under that unjust system. It's interesting also, and I like my colleague's question, but let me just respond to that about the law at the time. I remember another law, Jim Crow law, at the time. And the civil rights law corrected our society's ill of treating other citizens less than human, as second class. So anytime we can readjust, realign justice, it makes our society stronger. And so the cost, the burden of $1 is not nearly sufficient to make up for the burden of injustice as a society. So I thank you very much for bringing the bill.
Thank you, Senator Bowie, and I couldn't agree more. And I know I didn't go through the entire history of how that component of Louisiana's criminal justice system came to be, but I think everyone up here in this panel knows the origin of that Jim Crow law that you pointed out, and what was taking place at that time, and why it was put in place to begin with. And it was purely based on race. And it was purely an attempt to silence the voices of certain individuals who were citizens who would serve on a jury, particularly black people. And to your point, Senator Bowie, when you talk about the change that it took us so long to make in 2018, this is unfinished business. This is unfinished business. And I always felt like a level of gratitude and accomplishment that we as a state could wake up and say it's time to fix this, but we didn't fully fix it. We didn't fully fix it. We took a major step, but there's still a process that needs to be corrected. So
Thank you, Senator
I'll defer to Andy.
Yeah, we are about to take testimony in support of your bill. Absent the adoption of your bill, what is the relief alternatives available
under
to the pool, whether that's 800 or 1,500? What are the tools available to them absent your bill?
Well, again, there's well, I think we had other tools prior to the I want to say it was SB4 in the special crime session that narrowly limited post-conviction relief opportunities. That would have been an option for DAs to waive certain
extension of time.
Yeah. That was and is to a certain extent a possibility. There is always the opportunity to petition for clemency through that process, but we know how burdensome that is and how limited that can be. But I'm not aware of anything that gives us a specific opportunity to petition based upon a non-unanimous jury.
Okay.
Yeah.
Okay. Senator Duplessis, the board is clear. If you'd
I'm
like,
going to get out the way and allow
Okay.
for testimony. Yeah.
All right, sounds good. First of all, we'll enter into the record 125 cards that were in support, not wishing to speak. Thank you, Shannon. Moving to the cards in support, wishing to speak, we'll take in groups of 3, please. We have a Tashfa Davis in support, wishing to speak. Ronald Marshall with vote in support, wishing to speak, and Bruce Riley in support wishing to speak. If the three of you could come up now, we have overflow in room AB, so if you're not in this room and you're in AB listening to us and want to speak, please come over. Please proceed.
Thank you. My name is Bruce Riley. I'm the Deputy Director of Vote, and I'm also a proud graduate of Tulane Law School. And I just wanted to say that none of the law schools taught about non-unanimous juries. It's just been this mystery that one encounters, I think, when you get into criminal practice, that you realize that Louisiana is different. And it's not taught in the civil code at Loyola. It's not taught in the common law track at Tulane. And I just want to put a little context, too, on when a lot of these convictions happened. Think about where we were with indigent defense at the time. Think about where we were with Brady. There's a big reason why many crimes from the 70s and the 80s, the 90s, the 2000s were overturned. There were a lot of problems with cases. And so here you have the threat of a 10-2, where you know you need 3 people to say you're innocent. And folks would plead guilty if they were guilty, and also plead guilty maybe if they weren't guilty, because maybe the deal on the table, let's say 10 years versus life without parole, the 10 years maybe looked like your best shot at something. And so we're talking about people who literally said, I am so not guilty, I'm taking it all the way, I'm not taking the deal. And so knowing all that, I think we need to keep in mind the struggles of the criminal legal system at the time many of these cases happen. And going to something around the cost, I believe right now for about 800 people incarcerated in the system, it costs about $30 million a year. So I'm not saying that all of them would get out or that number would change all the way, but you have to factor in that cost as well. I know that you can prosecute a lot of cases, especially post-conviction cases, for $30 million. So that would potentially be a massive savings. And I would just leave by saying, if cannabis were legalized, how many people would we leave in prison and for how long for marijuana convictions? And in the same sense, when slavery was abolished, how many people did we leave in chains? The answer, of course, is 0. And this is a very similar situation. Thank you.
All right. Thank you very much. Welcome to the committee. Please introduce yourself.
Hi, my name is Toshfa Davis, and I'm speaking and representing my boyfriend, Devin Bonilla, that has been incarcerated for 10 years with a life sentence with a chance of no parole. Devin is actually an Iraq war vet, and he suffers from PTSD as well as TBI, which is traumatic brain injury. When he came back from serving his country failed him. They misdiagnosed him, did not, say they diagnosed him on a level of PTSD that was very mild, and he has a very severe case. He has been incarcerated for 10 years where he is not getting any mental health, physical health, with all the conditions that are in prison. This man was incarcerated on a case, on a second-degree murder for self-defense. That was not considered a self-defense case. This is someone that suffered from PTSD, was misdiagnosed, and is currently serving a life sentence where they're just throwing his life away and say, you have no chance of coming home. That's unfair to a person that needs medical attention and medical help in order to get that PTSD under control, in order to do, I have something that I wrote that I actually want to say. He served his country, and it's very sad that the same people that he served and protected, are the ones that are saying he deserves to serve a life sentence. I think that is very unfair. And it was not same thing. We're here for the 10-2. Not everybody agreed that he was guilty. Louisiana needs to do the right thing and end this evil law that was made years ago. And again, as he said, this was made in a time of, we all know when it was made. And so at the end of the day, we really need to think about that. There's a lot of families that need justice when, 12 jurors are not agreeing and you guys are saying these people are guilty. That is unfair. That is not justice for everybody. So we need to do better. There's a lot of families that get hurt by doing this. A lot of, self-defense shouldn't be taken as someone murdered somebody. If my life is in danger and I'm protecting myself, I don't know how that can be taken as a murder case. That makes no sense. There's people that are, suffering in jail right now due to certain people not taking things into consideration, or people looking at certain people by color or by race and thinking, not even realizing, and then at the time of when you're actually going in and standing in front of jurors and judges, they're not showing the whole videos. They're only showing what they want to show you. So, and a lot of people, and I've lost a child over this situation from the stress that this situation brought upon me while he was getting incarcerated. A lot. So you guys need to do better. As the justice system needs to do better so these people can come home.
Thank you for your testimony.
Thank you.
Joining us in the committee today.
Good morning, committee.
Welcome back.
I appreciate you, Senator Royce. My name is Ronald Marshall. I represent VOTE. And, this is a very emotional, painful conversation to have. I'm just going to say a few things. Jim Crow juries, as we know the history, was created by people who value the ideology of segregationists. And I don't believe there's anyone in this committee today who still value a segregated society where you have white supremacists overruling a lower class of people in their mind. I don't think nobody in this committee values that ideology today. But that's what the Jim Crow jury is rooted in. And for anyone to come up here and oppose this bill, they're telling you they still value a segregationist society. And that is so wrong. And we just changed that in Louisiana. We have hundreds of men who are incarcerated, have been incarcerated, no matter how you twist and turn it. Right is right, wrong is wrong. They should be given the opportunity to be considered by a jury that is fair and just, not a jury that is rooted in a value system of 200 years ago that sought to oppress a group of people for years. It's time to change that. And we can correct that injustice right now. Like Senator Bouye said, this is unfinished business. And we have an opportunity, we have the opportunity right here, right now, not next year. So many senators and representatives have brought this bill. And we shouldn't be here. We shouldn't be in the 7th year trying to correct an injustice that happened in 1898 or whenever it happened. It should have been corrected when the first representative or the first senator corrected. Why are we 7 years still pushing a bill to end Jim Crow? Why are we still pushing it? Does Louisiana still value the ideology of segregationist society? I don't believe that. I don't believe nobody in this committee values that ideology. And we have an opportunity right now to say that we are an integrated society, that those brothers and sisters who were convicted by a non-unanimous jury verdict, they are citizens and they should be given a fair shot at their freedom and be tried by a constitutional and panel jury. Thank you, Senator Royce.
Thank you very much. All right, call up the next group of three. We have Terrence Wynn in support, wishing to speak. Claude Michael Como in support, wishing to speak. And my longtime friend, Matt Bailey, with the promise of justice, in support, wishing to speak.
Good to see you.
Thank you for being with us today. Matt, glad to see that you continue to serve your community and follow through with things you're passionate about. So welcome to the committee today. Appreciate you being here.
Thank you, Chairman.
We'd like to start with you.
Okay.
If you don't mind, just introduce yourself for the record. We can proceed.
My name is Terrence Wynn. I'm an organizer from Shreveport, working with youth and helping with reentry efforts. I spent 30 years at Angola prison, and today I'm here to read a statement from the 10-2 Committee for Equal Justice. The 10-2 Committee was established in 2023 by people incarcerated throughout the state of Louisiana who have suffered long-standing and pervasive constitutional and human rights violations by Louisiana's criminal justice system. The committee's mission is to build a statewide movement of people incarcerated, their loved ones, and their communities, to advocate for a just remedy to correct the injustice of non-unanimous jury convictions in Louisiana. Louisiana's Jim Crow jury was enshrined into the state's constitution in the year of 1898 when an all-white group of delegates held a constitutional convention in the city of New Orleans. Their goal was simple and plainly stated for the record. Our mission in the first place is to establish the supremacy of the white race in this state to the extent to which it could be done legally and constitutionally, stated Judge and Convention Chair Thomas Amesis. The convention would ultimately produce Article 116 of the Louisiana Constitution, which made it legal to convict a person of a serious crime by a split jury as opposed to requiring all 12 jurors to agree on a decision. The law was written in order to convict African American defendants and disenfranchise African American jurors from civil participation. More importantly, the law allowed Louisiana to reinstitute slavery via its criminal justice system while mass incarcerating black defendants and enriching white corporate elites in the process. This political and socioeconomic aggression against Louisiana's African American communities has continued until the present day. As the numbers reflect, Louisiana's black residents make up approximately 33% of the state's population, but accounts for a staggering 69% of the state's incarcerated felons. In addition, Louisiana has more people serving life without parole than Texas, Alabama, Tennessee, Mississippi, and Arkansas combined. The vast majority of those sentenced to life in the state of Louisiana are black. 1 in 5 of those sentenced to life were unconstitutionally convicted under Louisiana's Jim Crow jury laws. In the year of 2018, more than 120 years after the law's inception, Louisiana citizens voted overwhelmingly to amend the state's constitution to end the racially discriminatory laws. Unbeknownst to the voters, the amendment did not provide a recourse for the 1,500 men and women who had been convicted by a non-unanimous jury and were serving their sentences across the state. Subsequently, in 2020, the United States Supreme Court in PJ's I case, Ramos versus Louisiana, declared Louisiana's Jim Crow jury laws both unconstitutional and historically racist. Yet once again, the court's ruling did not apply to the 1,500 men and women unconstitutionally convicted and enslaved under the law. The final decision was ultimately left to the Louisiana Supreme Court, which on October 21st, 2020, denied relief on PJI's case, Louisiana versus Reddick, abandoning once and for all many of the 1,500 men and women unconstitutionally convicted under the law to die unjustly in prison. Despite the Louisiana Supreme Court's refusal to provide a just remedy, the Louisiana 10-2 Committee remains undeterred in our quest to correct the historical injustice the state of Louisiana has committed against us, our families, and the communities from which we have been exiled. Not since the advent of American slavery itself has a single state within this country subjected an entire people to such an injustice as it has the men and women who remain illegally enslaved under Louisiana's Jim Crow jury laws. We ask the members of this sacred body to stand in courage and support Senator Duplessis' Senate Bill 383. This bill provides a path for people convicted with non-unanimous jury to receive a constitutional trial. Sincerely, the 10-2 Committee for Equal Justice. Thank you.
Yeah, thank you for your testimony today. Welcome to committee. Please introduce yourself for the record.
Hi, my name is Claude Michael Como. I'm from Bossier City, Louisiana, and I'm a staff attorney at the Promise of Justice Initiative. It's been almost exactly 4 years to the day since the U.S. Supreme Court in Ramos told Louisiana that the practice of incarcerating people with non-unanimous verdicts was not just unconstitutional, but deeply racist. And I want to be clear, Senator Couson, they said it was unconstitutional always. It's always been unconstitutional. It was specifically designed to deny black people the right to sit on a jury and have a vote, and at the same time ensure that Louisiana could incarcerate black people without having to bother proving guilt beyond a reasonable doubt. And while it has obviously been very successful in its intended purpose, it's also been effective at leaving every person in Louisiana less safe. And that's because it's a law that purposefully discredits the state's legal system and informs its population that it's less interested in finding justice and more about finding bodies to fill concrete cells. This bill would allow the hundreds of men and women languishing in Louisiana's prisons with no conviction to speak of a chance at a fair trial. Oregon, the only other state to have adopted a non-unanimous verdict scheme, has already done this, and when doing so, they concluded that the unchecked bigotry of non-unanimous verdicts undermined all of its citizens' fundamental constitutional rights and rightfully would not allow those convictions to stand. When our state's Supreme Court encountered the issue, it stated that it did not have the power to order new trials, despite finding that every person convicted by a split jury has, quote, suffered a violation of a fundamental right. It said that the power to correct this was this body, the legislature. The Supreme Court also noted that the district attorneys could grant individualized relief, but 930.10, a statute that was designed specifically for to help them do so, has been deemed unconstitutional. And after the special session, less options remain. So the responsibility really lies with this legislature to correct this injustice. And you will hear opposition that it's going to be difficult to administer new trials, and that correcting these unconstitutional convictions will not be convenient. But it is what must be done if we want to, as a state, have a credible, fair, and just criminal justice system. Thank you.
Thank you for your testimony. Mr. Bailey, welcome to the committee.
Good morning. I'm Matt Bailey. I live in Metairie, Louisiana. I'm originally from Gina, and I'm here today as a proud Louisianan, as a father, as a military veteran, as a staff member at the Promise of Justice Initiative, but I speak to you today as a victim, as a former victim of a violent crime. On October 30th, 2012, in Shreveport on Kings Highway, it was a sunny Tuesday morning. I was running an errand in a business parking lot, and someone came up and forced me into my car at gunpoint and held me for about 20 minutes as we drove around to ATMs, and I gave him money out of my bank accounts. Very, very traumatizing experience. What happened was someone was arrested for the crime, and I could not identify him because I never got a good look at his face during the encounter. There was one eyewitness, and the man was convicted on a non-unanimous jury verdict. As the victim in the case, I was really uncomfortable with the proceedings from beginning to end, and a lot of that stemmed from the fact that I could not pick this person 100% out of a lineup. And just kind of watching the machinery of the prosecution process and the public defense process was troubling to me as well. But it was very troubling at the end whenever the jury voted non-unanimously and he was convicted. And he was sentenced to 35 years. And the Promise of Justice Initiative represents him now as one of the many hundreds of people who have non-unanimous jury verdicts. So what I'm saying as a victim, I am not comfortable with this outcome. I am not comfortable that this person was sentenced to 35 years on a non-unanimous, unconstitutional jury verdict. And what I'm here to ask is that you vote to send this to the full body and let the full Senate discuss this really important issue that needs to be discussed, that needs to be talked about and fleshed out more. And that's what I'm asking you to do today. So I appreciate it.
Thank you very much for your testimony, all three of you. The next group up, we'll have Jermaine Hudson, Bobby Gumpright, and Talita Hayes. If the three of you could please come forward. Welcome to the committee today. Ma'am, if you'd like to proceed, please introduce yourself for the record.
Yes, sir. Good morning. My name is Talita Hayes. I am the founder and executive director of Not My Past Ministries. Not My Past Ministry is an organization that focuses on incarcerated families, uniting them, reuniting them together. I'm going to say a number. I want you to remember it. 32 years of a life sentence. I'm here this morning representing my husband, William Reese, who is formerly incarcerated in Louisiana State Penitentiary, that have served 32 years on a life sentence, and he was convicted by a 10-2 jury, and he was a first-time offender. I'm also here representing the incarcerated families who cannot speak for themselves today. Everyone before you have told you everything about the Jim Crow law. I'm going to tell you about the 1,500 people that are sitting in there waiting for their second chance. And I want you to think about this real closely. They were wrongly convicted, but they didn't give up. They went through Louisiana Department of Correction Rehabilitation programs. My husband has working on his second master's degree, went in there with not a formal education. He was convicted of a 10-2, didn't know if he would ever see outside. But he continued and went on to get a master's degree from the Bible College. He's a Class A trustee, an inmate minister. Just like my husband, the 15 men and women that are sitting there have went through all the programs that Louisiana Department of Corrections says they need to go through if they ever have an opportunity to go home. Today is the opportunity. Today is the opportunity to give them a chance to go back and get a new trial, to get the opportunity to show you all, even though y'all wrongfully convicted them, they didn't give up hope. They did everything that Department of Corrections said they needed to do. They continue to be a citizen in the community of being incarcerated. And I'm speaking with the families to let you know, families are rallying together. We support our loved ones. We support the difference that they are. These 1,500 men and women are not the same people that was wrongfully convicted when they first went into jail. They have taken advantage of everything that can help them to get out. I ask you to visit them, visit the institutions, talk to these men and women, and you would see they are not the same people that was convicted, wrongfully convicted, but they did not give up their fight. They did not give up hope. And your programs in Louisiana Department of Corrections, the programs that y'all say are approved for them to do, they're done it. So why be afraid to send them back through court and let them give the opportunity? Yes, you might find some people that are guilty, and you might find some that are not guilty that was wrongfully convicted, but they need their day in court. They need their day, and let you see that even though you wrongfully convicted me, I didn't give up fighting. I didn't give up hope of one day a door will open for me to walk out. I want y'all to understand, y'all programs for Louisiana Department of Correction Rehabilitation, they helped, even if they're guilty or not guilty. So give them their day in court. So I ask that y'all pass this bill. Pass SB 383 so they can have an opportunity to show you all. Don't be afraid of them because they took advantage of everything y'all told them to do if the door ever opened for them.
Thank you very much for your testimony, and thank you for your ministry, the work that you're doing.
Thank you.
Thanks, sir. Welcome to the committee. Please introduce yourself for the record.
Good morning, committee. My name is Bobby Gumpright. I live in DeRidder, Louisiana, and I'm here in support of SB 383. 25 years ago, I was directly responsible and contributed to the wrongful conviction of an innocent man, Jermaine Hudson, who sits to my left today. Based on my false testimony, he was convicted by a 10-2 verdict for the charge of armed robbery and received a staggering sentence of 99 years in Angola State Penitentiary. I have no excuse for the part I played in this tragic occurrence. I was broken, lost, and afraid. God mercifully entered my life, and after years of self-torment, I was convicted to come forward and tell the truth. The Bible states, "You shall know the truth, and the truth shall set you free." Not only did the Lord set me free, but my confession and repentance directly resulted in Mr. Hudson being freed after 22 years of false imprisonment. In recovery, we learn that it is necessary to admit our shortcomings in order to make the changes necessary to keep moving forward and grow in maturity. I believe this is not only applicable to individuals, but also to groups of people, organizations, and even governments. The author, poet, and civil rights activist Maya Angelou said, "Do the best you can until you know better. Then, when you know better, do better." I believe this body has made great strides in doing better for the citizens of Louisiana, and I'm grateful to be able to be here today and work with you to address how we can do even better together. In Article 930.4, the first clause states that only in the interest of justice should a repetitive claim be considered. Justice is defined as not only the administration of the law, but conformity to truth, fact, or reason. The truth is, hundreds of people are being currently denied justice and a fair trial that conforms to the reasonable statutes that this very body has authored. The bill you are being presented with today is not changing any of the original article language. SB 383 simply provides a pathway for relief to those that received ununanimous verdicts. Verdicts which the people of Louisiana have voted to be unacceptable in our court system and the United States Supreme Court has deemed unconstitutional. I urge you to consider the human cost of not providing this pathway for relief. I now humbly come before you to publicly apologize for the part I played in this, but ask that you look to and correct the fundamental system failure that allowed it to happen. Once we know better, we must do better. I've come before you today not in my own power. I did not have the strength to admit my mistakes. God gave me the strength to ask for forgiveness. The Word of God says, if anyone speaks, let it be as one who speaks God's words. If anyone serves, let it be from the strength God provides, so that God may be glorified through Jesus Christ in everything. To him be the glory and the power forever and ever. Amen. Amen. Thank you for your time.
All right, thank you for your testimony. You may introduce yourself for the record. You may begin.
Good morning. My name is Jermaine Hudson. For 22 years, I kept being denied in court. One word, denies. No explanation. The crime never happened. Again, the crime never happened. If it wasn't because I was convicted by a non-unanimous jury, I would probably still be in prison, even after the person who invented the crime came clean. That's how hard it is to prove you are innocent once you have been convicted. I remember at the end of my trial, the two people who said not guilty. I remember them. I don't know them personally, but I remember them. With two jurors believing I was not guilty, had my attorney allowed my two alibi witnesses to testify on my behalf, I would have been found not guilty. Incarcerated for 22 years, I've lost so much. I've lost my mother, two brothers, a sister, a nephew, so many. I've lost out on raising my daughters. I had to watch them grow up through prison. Today, I am here in support of the non-unanimous jury bill, praying that you guys pass this bill today, because you still have a lot of people that's suffering behind this, and today we can correct this. You have a lot of families that's still in torment behind this, and today, again, we can get this corrected. I believe in this system, and I believe in my heart that y'all will do the right thing today. I've lost 22 years of my life behind something that never took place, period. So I ask y'all today to please pass this bill. Do the right thing. It won't hurt y'all to do that. It won't hurt to do the right thing. It will hurt to do the wrong thing, but it won't hurt to do the right thing. Y'all have a good day.
You have a question? All right. If y'all will remain just a moment, Senator Duplessis.
Thank you, Mr. Chairman. I just wanted to just take a moment, not to ask a question, but just to express some thoughts. Mr. Hudson, I had the opportunity to meet you yesterday for the first time. I didn't know your story prior to filing this bill. And I want to formally apologize to you for what you had to endure and what you had to experience. And I want to thank the gentleman to your right for the step that he took, for the courage that you took to not only do the right thing, but to continue to do the right thing and to try to make right what was wrong. And what you are an example of, what the both of you are an example of, is why we're here today. Because it was said in your quote, knowing right requires us to now do right. We know that the non-unanimous jury law was wrong. And we know that the fact that so many individuals were impacted by it who are still incarcerated under this law is wrong. Now it's time for us to do the right thing. And Mr. Hudson, none of us could put ourselves in your shoes. So I want to thank you for your grace. your patience, and what you are continuing to do to try to right a wrong that was done to you, so that we can fix this for so many other individuals who were convicted by an unjust system. And you all are an example to that. You all are an example to that. And I didn't even know your story prior to filing this bill, but you are the reason that I filed this bill, because you represent so many others. And I just want to thank you for that.
You're welcome.
Thank you.
Thank you, Senator Duplessis, and thank all three of you for your testimony today. We have the next three up. We'll have Deidre Thomas Pierre, Kanan Cole, and Christy Cole. If the three of you could please come forward. Assuming these are the Coles. Deidre Thomas Pierre. Deidre still wishing to speak.
Deidre Thomas works with our office. I'm also, can I speak?
Yeah,
Part of the award.
you certainly may.
You can
Okay.
go first.
All right. Thank the three of you for being in committee today. You can start in whatever order you'd prefer to begin.
Hi, my name is Canon Cole, and I'm not used to speaking in front of everyone, but for the sake of my dad and to help the state, this is what I must do. My dad is currently in Angola, serving his life without parole, sentenced illegally. He had three jurors say that he wasn't guilty, and the judge made them go back in until they all agreed. One of the jurors was sick and throwing up and crying because they were harassing her and trying to make her change her vote to guilty. To make them stop bullying the girl, another woman changed her vote to guilty to get out of there. The lady that changed her vote said that my dad is a grown man that can take care of himself and that she has to protect the young girl that was being bullied. I visit my dad every other weekend, and it makes me sad to leave him. He is my hero, and I love him more than anyone else in this world besides my mom. We take fun pictures and laugh and joke the whole time. We play cards and checkers, and he draws with me. And although I love spending time with him, I feel like he has missed my whole life because of a racist illegal law. When I was little, my mom and dad told me my dad was at work, and that's where we were visiting him. He made me feel protected, and I never felt scared. One day I figured it out, and I realized what really happened to him. I feel that Louisiana has taken my dad from me. All of our lives have suffered because of one judge was corrupt. It makes me not trust anyone. No one that can make a change actually listens or seems to care that he is innocent. All I want is for people to be kind and loving and fair, and Louisiana is none of those things that are stated. I get kind of scared to stay here, and I want to move, but we can't because I can't leave my dad, because he is currently staying at Angola to where he's being locked up. I want to go to a state that is fair and actually listens when we try to tell him what is needed to make things better here. I would give anything for you to vote yes on SB 383 to help get my dad in a new trial where he is given a fair chance at showing everyone he is innocent and we can be together again. Thank you.
All right, thank you for your testimony.
Hi, my name is Christy Cole. I had a lot to say, but after hearing what you guys said at the beginning, I wanted to kind of touch on some of those numbers and reasons. I would like to take this opportunity to speak with you guys. As you know, my partner's currently incarcerated on a non-unanimous jury verdict. The question was asked, what are other reliefs that are available if this doesn't pass? There's post-conviction reliefs, there's habeas corpus, there was the 930-10. Just to let you know how hard it is to get seen on those, we were denied before we even got there. We had we had exculpatory evidence, 12 hard, solid findings from the files, the sealed DA files. All we wanted was just an evidentiary hearing, and we were denied. And just to also let you know, we have the means to get the best attorneys possible. We file way before we're supposed to file, and it's still denied, so it's very difficult. There's also, most of the people back there don't have the wherewithal to even have people come out and fight and look to where they should go. So just to give you a back history on that, it's very difficult to even be seen in court on your PCRs. So with that, I could spend my time up here speaking on how it's deep-rooted in racism. We all know that. And it was, before now, we know that it was unconstitutional. I have spoken to various district attorneys over the past few years just to kind of see what the concern is, and money is a big one. But as in January, it cost roughly $107 a day to house an inmate, which is over $40,000 a year. With the special crime session that just came and passed the bills, most of them are going to die back there. So just say 20 years, which most of them are already spent that long. That's upwards of $750,000 to $1 million just for one person. And that's not if they're needing constant medical care, which once you get upwards in age, it requires it back there. You really can't put a price on someone's life, though. Are all of them innocent? No, they're probably not. But like everyone stated, if you save one life, like the man that was sitting up here, 22 years was taken from him. And it happens often. And it's unconstitutional. It was always unconstitutional. The law that was passed slipped through the cracks. The United States Supreme Court didn't even know that we were giving verdicts on 10-2 like that. The issue is this. When I went to special session, I kept hearing the law of the land. It's the law of the land. When they asked, well, why are you passing this bill? It's the law of the land. Well, so is this. The Constitution is the law of the land. You can't pick and choose when you want to abide by it. It's unconstitutional. There's reasonable doubt. I feel that a fair trial, we're not asking for a handout or anything special. We're asking for the bare minimum, because actually illegal convictions should be vacated, and they're not. So just a trial is all we're asking for. We're not asking you to release these men and women. Another thing that was brought up was once they got to 10 guilty, they stopped it. That's not true. There's a jury poll. There's something called a jury poll where everyone's verdict is written down. They have to provide that verdict. Whether it is given to the court or not, there's a jury poll. So the argument of, well, they got to 10, so the other two probably would have voted guilty. Well, you'll know because it is on record. The reason they do that is if you go before and they say, the jury has found them guilty and everyone finds them guilty, if someone says, no, I didn't say guilty, they go back to that record to state, no, it was put in record, you said guilty. So they have to pull that record. And no matter if it was 10-2, 11-1, 12-0, it will be in that record if they voted guilty or not. So that's a null and void fact. But thank you for your time, and I really hope that you guys make this right and err on the right side of the law.
Thank you very much for your testimony. Appreciate that. And you're Mr. Ward, right?
Yes, sir.
Okay, excellent. Well, welcome to committee. Please introduce yourself for the record.
Good morning. My name is Hardell Ward. I'm the Director of Community Impact of Promise of Justice Initiative. I'm also the Managing Attorney of the Jim Crow Jury Project out of Promise of Justice Initiative. I was the lead attorney on State versus Nelson, which was the first case to apply Ramos retroactive in Louisiana, although it was overturned. That case was out of Calcasieu. I was a lead attorney for State versus Reginald Reddick, which was the case that would go to the Supreme Court. I mention that because I think it's important to understand these cases are through all parts of Louisiana. Calcasieu, Plaquemines, Monroe, Ouachita, Caddo, everywhere. The people here are from everywhere. We have people who bust in from Shreveport, Monroe, Alexandria, Lafayette, Lake Charles. This is a all Louisiana issue. This is an all Louisiana problem. The things you hear in the questions, which I would hope if you have any other questions I can help clear up, I think it's important to realize where we are as a state. We know we have these individuals who have illegal, unconstitutional verdicts, but they don't have a mechanism to even bring their case. Jermaine Hudson, there is no mechanism under the law at this current time where he could bring his case. Bobby could go to the DA now and plead the exact same thing. Because of the special session, it cannot be heard. A judge cannot hear it. A DA cannot waive the bars. It cannot be done. Jermaine Hudson would simply remain incarcerated for the remainder of his life merely because of procedure. Unless the laws change, that is how others will remain. There are other individuals in that similar situation where there is someone who has come forth to say, actually, it was me. Actually, it did not happen. But they cannot move forward because Louisiana's post-conviction laws require you to bring other than testimony evidence to even be heard. That is the state we are. So when we look at this population of people with non-unanimous jury verdicts, it is people who we know did not receive a constitutional fair trial. They did not receive a constitutional verdict, but there is no actual legal mechanism for them to show your case. And that is why we're here today and asking for a motion for a new trial, change that would give them a motion for a new trial. Not even direct relief, but a chance to go to court and prove their case and force the state to prove that they deserve to remain incarcerated. That is the situation we are in, and that is what we're asking this body to vote and move on to the Senate so we can effect some changes. Earlier today, there was a note that the fiscal note said there's 1,500 such cases. Sadly, that's untrue. I know where that number comes from. That was the number when the Lafayette Advocate first reviewed the cases. They suspected there were 1,500 cases. Promise of Justice have been reviewing these cases since that time. We only identified 1,027. Those are the number of cases that were filed. Since then, over 200 have been resolved. When I mean resolved, I do not mean they received some relief. Sadly, some have received relief, but sadly many have passed away. Less than a month ago, an individual who was working in Angola died while working, and died and will never receive justice and will never have whether or not his conviction was proper, whether he should have died in Angola while working. There's no way to give him and his family. We work to get his belongings, but there's no way there's no way to correct that. He will never see his wife again. He will never see his kids. And that is what we're fighting for. The number of individuals who are incarcerated throughout this state who know that their convictions are not just. And all we're asking is a mechanism for justice. You're going to hear from the District Attorney Association. I have talked with them for the last 4 years. And frankly, while they stand behind their verdict, as prosecutors do, the simple fact is they know that this is a problem. That is why they have talked with us for years. That's why they have brought bills with possible solution. They know this is a problem, and they know it has to be corrected. We go back and forth for ways of correcting, trying to find some other way of doing a new trial, but that is the mechanism under the law. That is the mechanism under our Constitution that respects the separation of powers, that puts the decision in a duly elected fact finder who is skilled to review the facts, and that allows us to reach a verdict that we can have faith and trust in. The number now is about 800 people. That is the number of cases. It breaks down to less than 2 per. The highest average would be Caddo Parish, which would be about 2.8 per their ADAs. But even then, we know those cases because many of the Caddo cases, the reason if they were given new trials, they would immediately be released because the only reason they are still incarcerated is because they were given habitual offenders on non-unanimous jury verdicts. So if you did new trials, by law, they are no longer habitual offenders. They would have to be retried on what, in many cases, are not even cases in which they could receive that verdict. So even if we did the work, the idea that it would be too hard or too erroneous is simply untrue. But also, I don't think it's the most important thing. The most important thing is that we are Louisiana, and right now we are the only state in the country that does this, that maintains this. And this has international intention. The way PGI was able to review that many cases in such a short period of time is we formed a coalition with attorneys throughout the world, Seattle to Singapore. The way that we kept this intention is that we have allies from the Players Coalition to French consulates who know of this issue, who wonder why Louisiana won't do the right thing and just do new trials. Not declaring anyone innocent, not releasing anyone, but simply get it right and actually find out who is guilty and who should be innocent. If Louisiana is going to be the be the incarceration leader of the globe, we should at least be able to say it's because they were all found guilty and not because 125 years ago, racists gathered to make our system racist. If you talk with your colleagues, one of your colleagues, I'm not going to say his name, is going to tell you that he considers this a tumor on the soul of our justice system. The only way you correct the tumor is by cutting it out. We have to simply address it. We simply have to do motion for new trials and go forth. The idea that it would be burdensome on the prosecutor actually is reverse. The reason our Constitution requires a speedy trial is to protect the defendant. A delayed trial benefits the state. So having to benefit for a motion new trial, many times 20 or 30 years later, benefits the state. It's the defendant who's going to have that burden, but that's what they want. You heard from the 10-2 committee. They just want their chance. So many individuals were innocent who did not take plea deals because they thought they would get their first shot in court. Yet in 1898, Louisiana created a system so that they would never get a fair shot in court, and that is what happened. And I have transcripts of DAs who, in their closing testimony, said, second-degree murder case, told the jury, I actually think this is a manslaughter case. Yet 10-2 manslaughter, and this person now has a life sentence. Had it been manslaughter, they would have been home now. They would have served their time. But no, they argued their self-defense. They argued their self-defense. They turned down the plea for 10 years, but now they're serving 40 and are due to spend the rest of their life until they pass away. That is what we are talking about, and that's where we have to make this path. The changes in the special session mean there are no other avenues unless we change the law. We cannot go back into court. The procedural bars, these are all procedurally barred cases at this point. And while there will be litigation, we will fight like heck to get this justice. The easier, simple way to save money is to simply grant the new trials. Because DAs will have to review our PCRs. They will have to review our motion to correct the legal decision. They will have to continue to fight these cases. They will have to defend these cases until our client's last breath because we owe it to them. Because we owe it to the families who are here, who came in. If the question is what saves the cost, just do it already. Do the new trials. Let's go and let's resolve this. Let the innocent go. Let the guilty serve their time. And we can have faith and confidence in our system. If you have any questions, I will open myself to them. I may be the person who has done more of these than anyone in the planet now. At Red River, I sit next to now Honorable Judge Lauren Lambert, who will not be, hopefully will not be speaking here today, but he would probably be the only other person who has as much experience in this in mind. So if you have any questions, I feel free to answer them, but I think it's very clear. You all know this is wrong. The question is, what is the solution? You got to take the simple solution, the one that's already in law.
Well, thank you for your testimony and your expertise and the time you've spent in this. You've undoubtedly impacted many, many lives in the process. So thank you for being here today. The board is clear. Thank you. The next three, Sharon Williams, Terry Landry Jr., and Edna Gibson, please.
Miss Pierre is here. You called her previously, and she was in another committee.
Oh, okay. Well, welcome to come forward. Welcome to the committee this morning. Please, in whatever order you'd like to proceed, introduce yourself for the record, and you may begin.
Hi, I'm Deidre Pierre. I'm a formerly incarcerated woman, having served 25.9 years. I was released November the 1st. As a counsel sub for 16 of those years, I had the opportunity to meet so many wonderful women that helped me along my journey. In that process, I've learned to gather information on our history, gather information from the people who knew more than I knew, and I even gathered information from the women I left behind, and I'd like to read something to you. This young lady feels like she's defeated, and she says, there was enough doubt in the minds of my jury that stayed deadlocked for 8 hours. When informed they would be sequestered until they reached a verdict, 3 jurors changed their votes. My verdict was a 10-2. I've been incarcerated for 26 years for killing my abuser. I had no prior arrest or even a parking ticket. In my 26 years of incarceration, I've done every rehabilitative educational program available to me and have been a trustee status inmate the entire time with no Schedule B violations for violence or contraband. A question that she posed, wouldn't my bed better serve someone who truly is a threat to society? Today I urge you, make history. Make yourself known for people that will not stand for unconstitutional convictions. You don't hear much from an incarcerated woman, but 40% of women incarcerated at LCIW with non-unanimous juries served over 20 years. These women have been separated from their families and their communities. The question is, what happened to their children? Many of these incarcerated women have invested in growth in education and still found ways to give back to their children. But mom is still not home. Because of being a council sub for so long, I gained an understanding, a respect for justice than I've ever had before. There's no way to try or justify the fact that Louisiana continues to incarcerate women, mothers, daddies, aunts, and uncles with unconstitutional convictions. This is not justice. It wasn't when their convictions were secured, and it definitely is not today. The bill proposed by Senator Duplessis is not asking to free people. He's asking to give them a fair and constitutional trial. Today, I hope that the legislature will be on the side of justice and that they'll grant the right of the women at LCIW in particular, a handful of women, as well as everyone else all over our state, providing them the basic right to a fair and constitutional trial. Today, I urge you, each of you, make history.
Good morning. My name is Terry Landry Jr. I am the policy director for the Southern Poverty Law Center Action Fund. I want to say thank you, first of all, for allowing me to be here with you all this morning. I've spent quite a few years in this building, in these committees, and talking to many of you over those years. And many times we hear what constituents have said. And you know, you all say, my constituents want this particular piece of legislation. Well, I believe that your constituents have spoken. Only 3 out of 64 parishes across the state voted in opposition to end non-unanimous juries. So it's only fair that we take that into consideration today. We also need to take into consideration the high wrongful conviction rate that Louisiana has. We always rank at the top in having wrongful convictions. We also know that, yes, this may be burdensome, it may cost an unknown amount of money at this time, right? But it's been almost 4 years since this law was enacted, which means that the individuals convicted under non-unanimous juries have served almost 5 years since the last person was convicted. How much is that worth? How much is it worth for Mr. Hudson's 22 years? I think the young lady gave earlier about it costing about $40,000 a year. You put that at 5 years, now we're at $200,000 for one person. Is it a trial to find that whether or not that person was innocent or guilty? Is that not worth it? We're also talking about jurors. But we know that when the law was initially incepted, that they not only faced corrupt jurors, they were corrupt DAs, judges, police officers, all who may have contributed to someone being found guilty by a non-unanimous jury. If this law is enacted, we have a chance to now have a more diverse jury pool, fairer checks and balances for DAs and judges, and honestly, a more just system. It's not perfect by any means, but I think it's better than what happened and what was enacted over the past years in which we saw this law being implemented. And so I think those things are important to know. I think that, you know, the Bible says, and I'm not, you know, one to seem to be, you know, seem preachy or anything, but I think that everyone here is a Christian, and we often hear the Bible quoted in this building. But I think in Matthew chapter 7, verse 14, it says the road to righteousness is narrow, and the gate is narrow, and that it leads to life. And those who choose that way are few. So I'm asking you today, be one of those few. We have a rare opportunity to correct Louisiana's wrongdoings. We often do work that is preventive and proactive. Proactive. Let's go back and change history a little bit. Let's apologize for the wrongdoings of our forefathers. And you have that rare opportunity today, and so I ask that you vote in support of this legislation. Thank you.
Thank you for your testimony. You may introduce yourself and proceed.
My name is Sharon Williams. I'm a naturalized U.S. citizen, a Christian, and a professionally trained educator. I came here to get an education and to make a better life for myself in the land of the free. Today, my son is currently incarcerated in Angola. My son was given a mandatory life sentence for second-degree murder. He has a story. I can't tell it for him. I can only tell you of my experience as a mother who has sat through a painful trial. My son is of my hue and complexion. The law says a jury of his peers. A jury of his peers was 11 non-blacks and one black alternate. These numbers would perfectly suit the injustice of a Jim Crow law of 10-2 conviction. I watched the jury selection process, where they asked only potential black jurors if being on the jury would affect them. Of course it would. Those of us who are not financially advantaged would say yes. I listened and watched in disbelief as potential black jurors eliminated themselves from the jury pool. The jury was stacked for conviction. The law at the time was designed to be unfair. It still is unfair. We as a group begin this life way behind the starting line. I heard about issues of cost. In prison, my son has more opportunities to better himself than he did before he got in trouble. Why are we so backwards? Why aren't we spending that money on the outside for people who are disadvantaged? Why aren't we spending more money on prevention? Desmond Tutu is quoted as saying that there's a time when we need to stop pulling people out of the river and go upstream and see why they are falling in the first place. The cost of incarceration and the cost of wrongful incarceration is, the cost of incarceration, the cost of wrongful incarceration in a non-unanimous jury is much more than the cost of righting the wrong of a racist law. In Louisiana, we are last in education, but among the highest in incarceration. An unfair law causes more people to fall into the river, to fall into the injustice system. It's time to do better in Louisiana, not only in education, but in the justice system. Please support SB 383. Vote yes.
Thank you for your testimony today, all three of you, and for being in committee. Next, in support wishing to speak, if you could come up now, Robert Jones, Emily Wright, and Gregory Earls. I don't have the card, but please come forward. Oh, okay, it was in that last group. Yeah, come forward. So Robert Jones, Emily Wright, Gregory Earls, and Ms. Gibson.
Yes, sir.
Okay. In whatever order, if you'd like to begin, please introduce yourself for the record.
Yes, my name is Edna Gibson. I spent 30-some years in LCIW for second-degree murder. I had a 10-2 jury verdict. Before I go, I want to apologize to all of y'all for my wrongdoings. Like I just spoke, that it was my mistake that I got myself in trouble. None of y'all was there. But y'all have to make a decision today. And whatever the decision is, I hope it's for the right reasons. And not for, just because it's who I am. I came from a family that believed in right and wrong. I wasn't raised to be like this. But yeah, I got in trouble, and I wanted to do my own thing, and I told my mama that, let me learn the hard way. And I'm learning the hard way now. I'm out of prison. I've been out of prison for almost 4 years. I received a pardon. So you said, why am I here today? Well, I'm here because I am starting over at 63 years old. I spent all that time in prison. Now I have to come out. I have to get a job. I have to get a place to stay. But you know what? People not listening to me now. I'm old. And I have a conviction behind me. I have to pay parole now. I have to pay money to pay parole. I can't afford that, but that's the position I'm in today. Because that's how it is. I know I got myself in this. I was 25 years old. I didn't want to listen. I did my own thing, and now I'm paying the consequences. Well, what I want from y'all is to please listen. Everybody want a fair chance. Because when I first came into the system, I believed in the system until I was incarcerated, and I had to go through. I was a paralegal in prison. I tried to help other people, and I seen how ladies, men and women, is being treated. We all make mistakes. Sometimes we get in something we can't get out of, but then we need help. But then everybody said, well, you made your bed, you lay in it. This sounds simple until it happened to you. I'm just in support of this bill. I'm just in support of this bill.
Thank you for being here, and thank you for your testimony. Ma'am, if you'd like to introduce yourself for the record, begin.
Hello, my name is Devin Williams, and I'm originally from Shreveport, Louisiana. My brother was arrested as a mentally ill juvenile and convicted by a non-unanimous jury. While we all agree that Jim Crow juries were created with racist intentions, I believe the disconnect comes into play when determining what's the best method of reviewing the cases. With respect to everyone and all families involved, I want to take this moment to highlight that our loved ones never received a fair trial. They were not actually proven guilty. One dissenting vote in any other state in this country would have not led to a guilty verdict. In my brother's case, his trial attorney just outright disregarded his job. Despite our families calling and writing letters to update him and make him aware of my brother's mental instability, he basically didn't listen. He did not investigate, or he did not build a defense. And even while he disregarded his job, there was still doubt among those jurors. Jim Crow juries are a direct violation of someone's constitutional right to a fair trial. My brother was convicted in a courthouse in Caddo Parish that had a Confederate statue right at the front door. I'm sad. I'm frustrated, but mostly I'm perplexed that we're still here in 2024 discussing how Louisiana has upheld racist practices in our criminal justice system. I was 12 years old when my brother was taken away from my family. He has daughters, a host of family and friends, and a community who support and love him. He is valued and needed within our communities. And when you have a loved one in prison, you're there with them. You are forced to pay very expensive fees when trying to care for them and simply just support them and give them their basic human needs. To know that your loved one is wrongfully convicted, but to add on top that they were convicted by a racist law is just sickening. Families impacted by non-unanimous juries have been coming here for years discussing this issue. And I want to personally thank Senator Duplessis for bringing this bill today. This bill shows that he has been attentive in those conversations and he has been listening. We've been begging lawmakers to properly address this issue. And again, Senate Bill 383 shows that our voices are finally being heard. So we fully support this bill as it's written, and we also humbly ask you to vote yes on Senate Bill 383. Thank you.
How you doing? Senator Royce, and thank you, Senator Duplessis. Just to piggyback on what she said too, I'm gonna make a little good trouble up here, in the words of John Lewis. And like she was saying, my niece told my brother that was convicted in Jefferson Parish, same parish that people love David Duke in, when people was doing the jury pool, and said, how y'all vote? Would you consider yourself more of a conservative person or more of a liberal person? Most of the people that was conservative was on that jury. So my brother already knew that this was about to go downhill for him. On top of that, just to piggyback on what she said about my brother with his niece, whatever, she just got into college. She was a straight-A student at Edna in New Orleans. A lot of people probably know about that school. And she told him, Daddy, you never probably gonna get out of jail. You got convicted in Jefferson Parish. You just need to give up on being a part of my life. That really hurt him a lot, because he'll never be able to see his daughter and be able to be in her life like he missed all those years, because he was convicted in 2009 in Jefferson Parish. And just like the other lady said about the river, they were sending people up the river to Angola, which was named after Angola, Africa. So this stuff been going on a long time, and this not a get out of jail free card. A lot of people that died over those 125 years. When you were saying about the money cost, think about how much money the state of Louisiana make off all those people in jail outside of the 10-2. Think about how many people never knew they had a 10-2 because they got rid of their stuff to show them probably their verdict, because it was so long ago, probably in 1895 or 1899, it could have been in the early 1900s. So all those people that's all in the hallway that got up early in the morning, 5 o'clock, 4 o'clock to catch a bus to be here. They got people all in the hallway. They got an overflow of people that y'all might don't see, but they here. I remember Representative Randall Gaines was putting this bill together too, and doing it for years and years. We've been coming up, and we're gonna keep coming. We're gonna keep knocking, because y'all predecessors put y'all in this situation. They probably, if they could look back in time and look right now, they'll be laughing like we caused the problem that they're still dealing with. Justice shouldn't have an expiration date. Those people, y'all, we stopped the fire at the bottom of the house, but they got people at the top still burning. And like you said, like that guy said that did 22 years, he would have never got a chance if that man, when it came clean, and said it was on my heart to say the right thing. They got a lot of people that never got that chance. They never got a chance to be with their mom, their kids again. They passed away. And if y'all could sleep at night with that, I don't know how you could sleep at night with a heart like that. So like I said, I just hope that y'all do the right thing. I hope y'all do what y'all predecessors couldn't do, had the courage to do, and make Louisiana look different. Because this feel like the antebellum South. Like the same old good old boys just doing this stuff, and everybody's just being like, well, it ain't my son. It ain't my nephew. So I don't care. It don't bother me. But those people look like me. And I know my brother a good person. I know he didn't get a fair trial in a parish that we already know how Jefferson Parish been historically the same parish that they told us don't come across the Crescent City connection during Katrina, Harry Lee. So how you gonna get a fair trial somewhere like that when the prosecutor's playing with loaded dice? A 10-2? Everywhere in the United States, you need 12 jurors. And at one time, it was 9-3. It was 9-3 at one time. Then they made it 10-2. And we still dealing with that. So if the voters could say, we tired of that and we want to end it because we was able to do it on a ballot, and I was out there with them voting in New Orleans and everywhere else, then we could do the same thing too. And y'all could do it because the Supreme Court said, Louisiana, y'all deal with it. Just like they tell Alabama, y'all deal with it when they sicking dogs on people and hosing them down, bombing churches. Y'all figure out how to deal with it down there. So it's the same way with Louisiana. But like I said, I just hope y'all get it right. I hope all these testimonies and people that was actual victims and people that actual said different things and then came back and recanted their statements, do it right, because there's a lot of people that, like they said, it was 1,500, now it's 800. But what about all the other people that died? So like I said, just think about those people over the 125 years that passed away that's never going to see this moment. Y'all could do something and make our ancestors or whoever, y'all ancestors even proud to say maybe your great-great-grandfather's on the wrong side of history, but you could be on the right side of history. That's all I got to say.
Thank you very much for your testimony, all three of you. Devin Williams, James Alums, and Ronald Marshall.
Ronald already testified and so did Devin.
Okay. Is James still here and wishing to? Okay. Thank you, sir. Please come forward, introduce yourself for the record, and you may proceed.
Okay. My name is James Allen. I'm from Ringo, Louisiana. It's about 30 miles northeast of Shreveport. First, I'd like to thank y'all for letting me speak. I'm just going to speak from my heart with this here. I left this last night at something to 12. It was storming there. It didn't matter. I was on the cap of the ground this morning, slept there, changed clothes, about 4 o'clock. My son is incarcerated in this state here. He's been incarcerated 21 years. He's 39. He was 18 years old when he got convicted. I'm not here to plead his case. I'm here to plead about the unjust jury. It was a 10-2. You know, 21 years. I've been locked up too. People that have people locked up, they locked up too. Especially, it's hard to deal with when it's unjust. You know, you can accept things if it's on the table and it's right. You know, I'm speaking for my sons, just I am, but I'm speaking for that, from 800 to 1,500 people that's locked up in this state here. Can we do better? Yes, we can. I never would have thought that I would be in a chamber like this here, testifying and pleading my case about the unjust. I was a guard at Angola. Never would have thought my son would have been locked up, unjust, with a jury. I was a guard at Wade Correction Center. Never would have thought that I would be here today here. I have been to Shreveport, Monroe, and this is my second time here. This bill here, 383, we can pass this bill. What I said we. Y'all are elected officials for this state here, for your district. We elect y'all to make things better for us. I heard one thing, it was talking about money. Can we put money on a person being locked up, saying, well, we can't carry him back because we don't have enough money to try him again? Can we put money on a person's life? Because if we do nothing, I said we because I live in this state, they're going to die there. I'm going to die seeing my son locked up. He's going to die in there if he don't get a release, a fair release. You know, if it said that if you don't do nothing, you're part of the problem. If you don't do nothing, you are part of the problem. You say, well, now, yes, you are. I'm speaking of me, myself. I asked the Lord to give me something to do here to help my son. And that's what I'm doing here. And I'm speaking on my son, but everyone that is locked up here in this state here. We can do better. You have other states have did better. You mean to tell me Louisiana can't do no better? Something wrong with that picture there. We need to go back, dissect this thing here, and see can we do better. We can do better. And I thank y'all for letting me come here and speak today here. And I wish y'all see it in y'all heart to let's do something here. We just can't just, can we afford to leave them there? Can we afford not to say anything? Can we afford to say, well, that was a law back then, so let's let it stick right now? We cannot afford that. you know, whatever you do, your record gonna speak for yourself. If you do nothing, that's what your record gonna speak. They're gonna say you did nothing. But if you try to do something, your record gonna speak, I tried to do something. Thank you.
Thank you very much for your testimony, joining us in committee today. All right, members, we have 30 other cards that are in support, available to speak. If your name has not been called and you were one of those folks that wanted to speak if asked, you're certainly welcome to come forward now, introduce yourself for the record. 3 at a time. 3 at a time, yeah.
Yes, sir. Yeah,
And while they're preparing, we also have 1, 2, 3. We have 7 other cards in support, not wishing to speak, would provide information if requested, and those will be entered into the record as well. Begin and introduce yourself for the record.
yes. May the peace and blessings of God be upon you. My name is Nadia Muhammad Southall. My husband, Johnny Mitchell Southall, has been an award of the state since the age of 5. His mother, he never met. His father took him at birth from his mother. At the age of 5, Johnny saw his father murdered by his aunt, his mother's sister. Johnny was placed in foster care. When he aged out of foster care, with little or no education, he began as a petty thief and ended back in the system as a habitual offender because he had no living relatives, so they figured that's best for him. His DOC number is 96975, 96,975, and today I know it's well over that. Johnny's last incarceration was April 3rd, 2016. He was on the 3.5, they gave him 3.5 to 7 years for a violation and 10 years of probation because he was on the 17-year probation. This sentence was given for a violation that we turned and copped to the plea. He was charged with theft of $93,000 worth of merchandise with no vehicle to take the merchandise with, and a picture of the back of a person they said was him. Johnny was unknowingly involved in an insurance fraud to revive the company from a loss. His conviction gave the company a way out to file theft. With the help of Johnny, the groundskeeper, all the other employees was laid off except him, the owner, and the owner's best friend. I'm pleading with you for the assistance of the releasing of Johnny Southall from Elaine Hunt's Correctional. He's a Class 1 trustee, a cook. He only earns 8 cents an hour and a model inmate. He told me that when he get up to $250, he can get his money out. He's been there 8 years. I asked him how much he have. He said $175. Although Johnny doesn't have any living relatives, he has the support of my entire family. His actions over the past 8 years has been a character of a model inmate. I met Johnny at our place of worship. After 3 months of courtship, we married on December the 27th, 2015. Only married for 3 months before the incarceration. At the time of the incarceration, a non-unanimous jury led him to a 40-year conviction. Jim Crow, the 6th Amendment, 7th Amendment, the 10-2 committee all failed him. Johnny was paying his parole officer on time. He was the employee of the month. If you asked any of the employees about his character, they would say he was well-liked and did a wonderful job, always on time. Johnny showed no lack of ability in his title. His pink slip said no call, no show for 7 days, even though he was working at the time when they called the police on him. Johnny went with the police willingly because he had nothing to hide. His lack of proper representation after being released on the 2045 states that a person who is ineligible for parole can be considered after serving 25% of his sentence. His current conviction automatically revoked back to the original sentence, and his attorney never brought up the DOC because he didn't review his file. We took a plea deal on the attorney's advice. This led us to living now 8 years apart. I have suffered my own mental health breakdown as it relates to this incarceration. I'm pleading with you to approve the SB 383 and set him free to live the last part of his 66 years of incarceration as a free man, a free husband, a free father, a free uncle. And I thank you, Representative Duplessis, for allowing this bill to be heard and your colleagues to accept the plea. Thank you, Nadia Mohammed.
For your testimony, and I just remind everybody we're going to be up against a hard stop here soon, and so please, if you can, limit your comments, and we'll try not to be repetitive and give everybody that wants to speak an opportunity to do so.
Thank you.
Absolutely.
My name is Gwen Robertson, and 24 years ago, I started an organization because my best friend that had cancer, brother, was incarcerated, and I traveled up and down the road with her to Angola. The whole time, I never believed that he was innocent, because in my mind, when a person go to court and go before a jury and all the evidence is presented, once they're found guilty, I believe they're guilty. Well, I was glad that I never told that to my friend, because after she passed, her brother wrote me and asked me to look at his transcript and try to help him, in which I did. I ended up looking for pro bono lawyers and ended up with the Innocence Project of New York, which took his case on pretty fast, even though he told me that was a long shot. From there, I have over the years networked with several lawyers, private investigators, and even forensic experts that just me writing the stories and the facts of Guy's case have came on pro bono and helped to free him. I went before the Pardon and Parole Board for several guys. I've helped several guys wrongfully convicted to get their freedom. And about 9 to be exact. And out of those 9, none has reoffended. I sit here today because of the 24 years that I've been incarcerated, not one of the people incarcerated are related to me. But I believe God called me to do a job. And I've tried many times to quit that, but was not able to do so. I was not elected to fight for justice. I was not paid to fight for justice. I was called to fight for justice. We, the people of the state of Louisiana, elected you all to do the right thing, to uphold justice. Over the years that I've done this, in the 24 years, all of the people that you've heard testified, all of that just so, I've heard it over and over again. These people, not only the ones that's wrongfully convicted, but even some that have received sentences that's harsh or the wrong sentence, when it should have been manslaughter, it was second-degree murder. A lot of this come from prosecutorial misconduct, police misconduct. It's not just people committing crimes, and I can't express enough the fact that we need to redo our criminal justice system. We need to do what's right by the Constitution. You all was elected to do that. I want to thank the senator for bringing this before you all. Senator Bowie, you said enough. It was well said. I came before the legislators in 2005 for a bill that Senator Glover authored, which was a compensation bill, because at that time, Louisiana didn't have a compensation bill. Again, I tell you, I'm not fighting because I have people incarcerated in prison, but it could very well be my people, and it could very well be your people. What we need to do is make sure that justice prevails for people who need justice. Please vote for this bill.
Thank you for your testimony. Please introduce yourself on record. You may begin.
My name is Sandra Jackson, and I'm here on behalf of my brother, Melvin Jackson. He's been in Angola now, going on 26 years. And he was, I think he was really messed over by the justice system from the time he went in there. He had a lawyer. that told him to turn himself in. And he did that because he had never been in any trouble before in his life, ever. When he was convicted of this crime, he was a small business owner. He owned his own cab company in Baton Rouge, Louisiana. When the lawyer had him to turn himself in, when they took him to the interrogation room to question him, the lawyer looked at him, told him he would be back, and he left, and he never went back. So they questioned my brother without a lawyer there. And I don't think, a person that's never, ever been in any trouble with the law should be convicted for murder and have the benefit without parole. I thought first offenders was supposed to, maybe, I'm not going to say they should have let him go. Some of them they release on their own cognizance. No, he didn't have that chance. The judge and the prosecutor that worked that case, they just wanted, I guess, to make an example out of him. And I don't remember the prosecutor's name, but I remember Judge Linda Holliday. That's the ones that convicted him. Not long after he got convicted, those two people, Linda Holliday and the prosecutor, was made to resign for some reason. So evidently they were doing something wrong. So I'm just hoping that someone would actually take a look at my brother's case and see that he really wasn't guilty of what he was accused of doing. And there's no way he should have gotten life without the benefit of parole for a first offender. So I'm just hoping that you all could find it in your heart to pass this bill on behalf of everyone that's in Angola unjustly. Thank you.
Thank you for your testimony. I believe that concludes the testimony of those that were wishing to speak. Okay, I will tell you that we're happy to. I don't want to take away anybody's opportunity to speak, but we are going to be up against a time that this committee has to adjourn. If you have something different to say, if there's some area that we haven't covered, Senator Duplessis, I certainly defer to you in how you may want to proceed, so that everybody has the opportunity, but that we also have the opportunity to hear the remainder of your bill.
Sure. Thank you, Chairman. And I certainly want to hear from everyone. And we know that people went through great pains to be here today, took a lot of time out of your schedules, and you all have very important testimony to share with us. I would just ask that you just try to keep it as brief as you can. We still have to hear from anybody who is going to come to the table and oppose this testimony. We still have work to do, right? And I'm just asking that you come, if you're going to share your testimony, please just try to keep it as brief as you can. I know that might not be easy to do, but I'm just asking that you keep that in mind, because we have to go on the floor at 2. We still have some other bills to be heard. So I want to thank you, Chairman. Thank you, Chairman, for always being a great chairman and giving everyone an opportunity to speak. But I'm just asking that you please try to keep your comments as brief as possible.
Thank you, Senator Duplessis. Again, please introduce yourself for the record. Proceed in any order you wish.
My name is Ella Jean Jackson, and I'm representing my son, Andrew J. Hunter, Jr., DOC number 725707. My son was wrongly accused for, I'm the one turned my son in to save his life. He was I reside in Ponchatoula, Louisiana. I was in Ham, Louisiana at the moment. And I called the police because my son was ready to turn himself in, even though I know that he wasn't guilty of the area that they had, because the person had chlamydia, both of them, and my son didn't have it. And he volunteered his DNA, and everybody else refused. So I appreciate if you all can find this way to pass this bill or something, or help out the ones that's wrongly accused, and look at their records to see if they can help even 911. It wasn't him. He was in a lineup it wasn't him. The voice wasn't him. So I appreciate crying out for help.
If you'd like to introduce yourself, the record proceed. Thank you.
Good afternoon. My name is Mrs. Lakeisha Jackson, and I'm speaking in behalf of my son, Rajay Dumas. My son was indicted on first-degree murder. His case was kind of like swept under the rug. He was allegedly convicted for killing the stepdad, my husband. It was a long history of abuse, child endangerment, molestation for like over 20 years. And excuse me. So when they convicted him, they didn't have any proof, no evidence, nothing. The DA even told me when I spoke with him, I know that you guys are the victim, but, and I knew what the but meant. So the attorneys that I had to get, I paid like over $105,000 just in attorney fees. My son went from being a college graduate to going to professional football to prison. Never been in any trouble. I taught him, learned both of my children to be law-abiding citizens. And as he got convicted, he didn't think that he was going to get convicted because he hadn't done anything. It was no proof. So he would call me, and in his mind, he was like, well, how, Mama, how? And I couldn't explain, like, the elephant in the room about the racism. How do you explain that to your child, that you never taught him anything about that, to look at people as color? So I don't want to keep going on and on about it, but his case was swept under the rug. A lot of people know about the case. The case was in St. James Parish. Another young man that killed his stepfather, he was granted a Netflix documentary, I Killed My Dad. And they did his case pro bono, and they had researchers and investigators into why did this child actually commit a crime like that. And that young man confessed to the killing. But with my son, we had none of that. The attorneys, the DAs, it was so bad to where in the courtroom, the DA and the judge were arguing. It has left scars in my family that will never go away. Health issues for myself. I've had blood vessels bust in my eyes, and for a lot of young men that are going through what I'm going through, and you just don't have the words to even say, or what can you say? And who do you blame? Like, who are you gonna turn to for help? And I just sit here today and ask anyone that has humility for anything that is done wrong, if you have the power to make it right, make it right. Because I truly believe in the end, we all have to answer for our wrongdoings. Whether we're wrong or right, we have to do the right thing. Because it affects us all. It affects everyone, the world. So that's some of my story, because it's a lot. But that's my story with my son. From professional football, college graduate, he can't even take any programs in prison because he's done it all. He's educated. Never been in any trouble, never even had a traffic ticket. And he was convicted. They tried to give him life. He had an ununanimous verdict. They had a hard time finding a jury because the community knew of all the abuse with my husband that I was married to. So it was like a hard case from the beginning, but they just pretty much did what they wanted to do for a conviction, and here I am 6 years later, still feeling like it was yesterday. And I never thought I would be sitting here talking like this. I never, in my wildest dreams, that I would even be going through this, that we would be going through this. So the scars that things like this leave mothers and children, fathers, you know, I mean, some people deserve to be in prison and to be rehabilitated if they can, and some don't. And I'm sorry, so I'm done. I'm done. I'm sorry.
Okay, my name is Ramsey Murray from New Orleans. I'm gonna make this brief, although I wish I can go in. When we're dealing with Jim Crow, we know that Jim Crow is founded in racism and oppression. And I have a lot of respect for Senator Duplessis for even bringing up this bill, and also Senator Bowie for addressing it the way it is. But indirectly, the idea of us having to communicate about a law that was put on the books to keep blacks from being able to represent themselves properly during a time when we were being terrorized, oppressed, and also the idea to have to think about the cost that it would cost to overturn this law when we're talking about the very people who built the country, the very people who, you know, we fought for civil rights to be equal citizens, to be in the positions that we're in now, speaking in front of this committee. So this is not a matter of financial responsibility or money. It's a matter of correcting a wrong that should have never been on the books in the first place, that's affecting everyone, you know, in this country. I understand that the prosecutors want to speak on their prosecutions being, well, at that time it was the law, so we should not have to feel any type of remorse about something that was legal. But that's just like when we got our civil rights. Should our parents not get their civil rights before all the children that's born after 1968 have the right to vote? When we're looking at situations like that, racism is not nothing that white people had to bear the burden of. Whether you're white supremacist or not, you still benefit from the system in itself because it's not aimed at you. It's aimed at us. So with this law, if we don't believe in racism, or if we want to correct the things that's been done in this country wrongly and be a symbol of justice, then we have to vote for this bill and make this retroactive so we can get the inmates a fair trial. We don't know if they're guilty or if they're innocent. We didn't have a fair trial. And when we have a law like the unanimous decision, it opens the door for racism in the courtroom to where they can coerce deliberations and coerce the type of verdict that they want, as we see in the case with Corey Miller. You know, his first trial was a mistrial. The judge that allowed him out behind a mistrial got chastised behind that, even though he was never rightfully convicted. We don't know if they're innocent or if they're guilty until they first get a fair trial, and that's what we pay our tax dollars for. You know, we don't pay tax dollars to, you know, we shouldn't have to sit at our own lynches and our own hangings. And if we understand that that's what that law was placed in the books for, it should automatically be retroactive, just for the fact we didn't get no reparations. We have to rebuild from nothing. And the very people that's complaining about the cost is the people that we put in power. You know, we built the infrastructure of this country before any of the immigrants came in. When the immigrants came in, it was to flood us out. I'm not going to go on and on about it, but however, we need you to vote on this bill. It's a moral responsibility.
Thank you all so much for your testimony. Okay, that concludes the green cards. Or do you have someone else who? Okay. Yes, listen, even though you haven't filled out a card, if you want to take a few minutes to testify, we will afford you the opportunity to do so. If not, yes, ma'am, you want to do something? Okay, please sit down and state your name for the record.
Hi, my name is Peggy Lannery. I'm here on behalf of all the men and women who have been incarcerated by a non-unanimous jury. My brother, Mickey Lannery, has been incarcerated for 39 years. 39 years, and he was convicted by a 10-2 jury. He denied a plea deal. He would have been out 30 years ago, but he denied a plea deal because he did not commit this crime. He said, I did not rape this woman. And so now he went to court because he didn't take the plea, and he was convicted for life without the opportunity for parole. We need to do something different. In 2018, the people of Louisiana spoke about the non-unanimous jury, and the Supreme Court said it was unconstitutional. Please right this wrong and vote for this bill. I ask you to do this. Thank you.
Thank you so much for your testimony. Would you please state your name for the record, please?
My name is Amy Richard, and I'll make it brief. My fiance is incarcerated with a life sentence without the eligibility for parole. We grew up in Terrebonne Parish together. He was convicted by a 10-2 jury. His case, even the judge tried to, the trial judge at the time had even taken it away from the jury, acted as the 13th juror. He had never done that before or since because he knew something wasn't right. We have gone through the pains of I'm a conservative. I believe you go to court, you get convicted by a jury of your peers, you must be guilty. Well, I know that's not correct now because I've watched this. He's been incarcerated for 18 years, and I just want to say that the Apodaca of 1972 that made this legal to be convicted with a non-unanimous jury, that it was a very divided case, and the dissenting opinion even said that according to Duncan, that Justice Powell even said that a non-unanimous jury was understood in the Sixth Amendment, but that the 14th Amendment supposedly didn't apply here to the states. But in Duncan, which was in 1968, it does require that the states follow the Sixth Amendment to have a unanimous jury decision. And I would like to say, as a conservative, I lean conservative, that if we want to amend the problems between the black and the white race in this state, this is a good way to do it. To say, we care that this was wrongly done. We care that things need to be right. And I'm going to quote someone that our whole legal system is based on, Sir William Blackstone. He says, punishments of unreasonable severity, especially where indiscriminately afflicted, have less effect in preventing crimes and amending the manners of a people than such as are more merciful in general, yet properly intermixed with due distinctions of severity. Also, our founding father, John Adams, in defending the British soldiers that in the Boston Massacre, he even agreed with Blackstone's formulation, which our legal system is derived on, which is innocent until proven guilty. And, okay, I have to say one more thing. If you want to let the people of this state know that you care about what was done wrongly in the past with the Black people, then this is a good way to show it. This is a good way for our governor to support that he's not a racist. This is a good way for all of us to say we care about what happened before, and we are going to make an effort to show you that we care. So please do.
Hi, I won't be long. My name is Jessica Severin. I come to you. I'm a taxpayer citizen in Jefferson Parish, but also in Louisiana. Just long story short, like the guys say, morals and principles, we live by them and abide by them. One can be negotiating and the other one can't. This is way overdue, and I feel that we just shouldn't be here having this discussion. But as I drove in and meditated to the God that I serve, this was in the quote for today. As believers, we can trust God to guide us. Pray for our leaders to have wisdom and know that everything is under control of the King of Kings. And we do not need to wait for eternity to begin living in the kingdom of God. It's already here. In Luke 17:20-21, Jesus told the Pharisees that his kingdom was already present. Today, too, it's happening among his people right here and right now. Let's make the right decision. I wear this shirt today. It says, it's not what we say, it's what we do. Thank y'all. And thank y'all all for being here. And I know that y'all going to make the right decision. May God's grace be with y'all.
All right. Thank you for your testimony. Does that conclude? Okay. Members, we will now move into those in opposition wishing to speak. So we should have Zachary Daniels, Executive Director of the Louisiana District Attorneys Association. And I wasn't certain of Billy Joe Harrington, President of the District Attorneys Association as well, speaking. We also have cards in opposition, not wishing to speak, from Philip Terrell with the Rapides District Attorney's Office and Kurt Wall with the 21st Judicial District Attorney's Office.
Thank you, Mr. Chairman. Zach Daniels, Executive Director of the Louisiana District Attorneys Association. Listening to the comments the chair made about the time constraints you're under, with everybody's consent, I'm going to condense the comments and testimony I know the fellow DAs at the table would make into my testimony to save a little bit of time. One point that I would begin with that I feel is vital to focus on is the difference in number. Because we do believe that this is not an 800 figure, that this is closer to 1,500 people. And we base that belief not on necessarily research we did independently, but on the Promise of Justice Initiative brief filed to the United States Supreme Court indicating there are roughly 1,600 people incarcerated in Louisiana under a non-unanimous verdict. That was filed in 2020, July 21st, 2020. So that's where our 1,600, 1,500 number comes from. While there might be some debate as to what it is currently given the clemency procedures, given post-conviction laws that have changed over the last several years, I do think it is important to be very clear on the prospects of retrying that vast number of defendants, most of whom constitute the worst of the worst offenses: murders, rapists, those who are incarcerated for a life sentence, some of whom are 10, 20, 30 years old, and were at the time of their conviction, according to the United States Supreme Court precedent in Apodaca, valid convictions. The Apodaca case, I think, was discussed by a number of different advocates, and I understand it's a plurality opinion. It leaves a lot of room for discussion among those who read it, but the people in Louisiana prosecuting, the judges in Louisiana adjudicating cases, the defense attorneys in Louisiana believed that was the law of the land and believed we were following the rules that were in place at the time they were there. While that was reversed in the Ramos case, it has also been addressed several other times. So the United States Supreme Court has also addressed this in Edwards v. Louisiana and indicated the federal Constitution does not require, the fairness of these convictions do not require being overturned retroactively. The Louisiana Supreme Court in the Reddick case also looked at this same issue and said, our Constitution and the fairness of these convictions does not require retroactive application of the unanimous jury verdict requirement in Ramos. I point that out because those two cases are from in Louisiana, what is usually considered the body of the best jurists in our state, and in the United States, the best jurists that our country has to offer in the Supreme Court justices. And they reviewed this in detail. And while there has been a lot of discussion about what it would look like from the perspective of what has happened, what I would focus on is the cost. There would be an extensive cost to retry all of these cases, some of whom are factually impossible to retry, some of whom the evidence is no longer present because it was believed to be a valid conviction so long ago that it is impossible. And that's not a destruction of evidence argument. That is the mere fact that 30 years ago, the witness who was present in court that was able to help convict a defendant may not be available to do so again. So we would be throwing these finalized verdicts to the wind, some of whom do not have anything to do with guilt or innocence. The final point I would make is that it is often used as a euphemism. A non-unanimous verdict, a non-unanimous vote is a euphemism for a vote to acquit. That is inaccurate. We have a responsive jury verdict system in our state. A defendant charged with first-degree murder can be found guilty of a lesser included offense of second-degree murder. I have personally tried a case where the two jurors that were not unanimous in a first-degree murder said, we believed he was guilty of first-degree murder. The other 10 thought he was guilty of second-degree murder, and because both were a life sentence, we did not need to continue deliberating. So there are a number of cases that would be impacted by this where evidence is not the issue, guilt or innocence is not the issue. And additionally, the non-unanimous experience I've had that really stands out is there have been cases that I've anecdotally been a part of that guilt or innocence was not the reason for the lone vote to dissent. We had a case that the person, even though we had asked them in jury selection, can you vote if you believe they're guilty for a life sentence? When it came down to it, they said, I know he's guilty of beating his child to death. But it was my decision, and because it wasn't required to be unanimous, I decided I was going to vote no, because that was too difficult a choice to make. These votes don't always have to do with guilt or innocence. There is a large swath of these cases where the votes could be for a higher offense, where the votes could be swayed by areas that have nothing to do with guilt or innocence. And I would point out that the retrial of these cases would prove problematic. The retrial of cases that are 30 years old could prove impossible. And when these are the worst of the worst offenses, and we believed at the time the conviction occurred, at the time the appellate court reviewed it, at the time the post-conviction occurred, at the time the habeas occurred, all of these court reviews of these cases, all the while defendants and defense attorneys were continuing to ask the Supreme Court to overturn apodaca when they could. And we received no feedback from them until the 2020 Ramos decision. So the 42 district attorneys of the state of Louisiana do have a consensus opinion. We do oppose this legislation because of the very drastic impact it could have, the impossibility of holding these defendants, again, some of whom have a non-unanimous verdict that has nothing to do with guilt or innocence, accountable for their conduct, and the inability to continue the finality of the victims of these cases, many of whom have believed that the person who murdered their family, the person who raped them at gunpoint, have a valid conviction, and this is done for them. This would reopen that wound in a way that we possibly could not fix. I can't answer any questions if there are. I know the chairman has indicated there's a time constraint, so I do appreciate the time that this committee has afforded to us, and I hope I have condensed the positions of the district attorneys in the state down to a relatively concise statement. I thank you.
Thank you for your testimony. We do have a question from Senator Duplessis.
Thank you, Chairman, and thank you for being here today to address the concerns of your organization and those of the district attorneys. And they are consistent with what we have always believed them to be, the issue of cost. I just want us to just walk through a little bit of some of the testimony that we heard today. Very compelling testimony, at least from my vantage point. And I don't know if you agree or not, but we started off talking about the number, 800 versus 1,500. I just want to personally say, and I think there can probably be some clarity provided as to why that number may have gone down from the pleadings that you cited. But I just want to personally say that whether the number is 800 or 1,500 or 15,000, it doesn't change the principle of why we're here today. So it's not about the number. I just want to start that from a foundational standpoint. It shouldn't have to do with anything regarding the number, which leads to the next question about the cost. I guess my question to you is, when we talk about dollars and cents and the cost that it might have on our state or our system, what about the human cost? What about the human toll and the cost that it has to individuals like Mr. Hudson, who testified earlier, that under the law of today, based on what we did last legislative session, we know that an innocent man who was convicted by a non-unanimous jury would not have an opportunity to petition for his relief post-conviction.
Certainly.
Can you please speak to that?
I do. The human cost is one that we can never weigh. I'll be honest, I've heard the testimony. I can't individually relitigate any of this. I've heard people that I believe are telling the truth, people that are testifying and advocating before this committee in a concise and truthful manner. I don't want to dispute any of those one by one. But what I will say is that post-conviction relief, where you have landed this law, is a legal analysis. And what you were talking in the human cost is already addressed in the law. The human aspect of the criminal justice system is taken into account in the clemency procedure, Senator Duplessis. The clemency procedure is long given the opportunity of people who believe that there is a material injustice, that there's a human cost to their continued incarceration, an avenue to get their conviction not overturned, but to get their jail sentence reduced to allow for their relief. So I would say that the human cost is currently addressed by the clemency procedure.
And we'll probably disagree on not the fact that we have a clemency procedure, but that the clemency procedure is an effective tool or mechanism to address these wrongs or these non-unanimous juries.
Certainly.
So we disagree on that. But you mentioned that this euphemism being used when the reference being made to the non-unanimous jury, you cited it as being a euphemism, being that of those two jurors in any particular trial that might not have voted to convict, we don't know what the reason or rationale might have been. And you suggested that it was a euphemism to say that that everyone who testified here today, that of those two jury members, that they believed the person was not guilty, that was a euphemism. You said that we don't know what they thought, right? So my point is that because we don't know what they believe, therein lies the problem. We don't know what those two jurors may have thought. They may have been polled and they said, we don't believe this person is guilty. They may have not been polled. But regardless, it leaves open the question. It leaves open the question. And my question is, why do you believe we have a system that requires guilt beyond a reasonable doubt? And why we have a system that requires all juries, that all 12 of those juries agree, regardless of any euphemism or suspicion as to what those other two might have believed. Why do you believe we have a system that requires that all 12 jurors believe that the person is guilty beyond a reasonable doubt?
And Senator, I believe it was your instrument, was it in 2018, the prospective unanimous jury? I believe it was your instrument that passed it.
No, not. Oh no, that was Senator Morrell at the time.
I apologize
yes.
for getting that confused. I had
yes.
it in my head that it was your instrument. Is that the voters looked at it and said, in a prospective sense, do we want to change how we are doing things? And then based on that, and that was incorporated into the arguments in Ramos, into the arguments in Edwards, into the arguments in Reddick, and the Louisiana Supreme Court said that the non-unanimous verdict is not necessarily indicative of a material injustice that would upset the beyond a reasonable doubt standard. The state Supreme Court in Louisiana said that. In Edwards, the United States Supreme Court said that the retroactive perspective here is not required. So I understand that the proof beyond a reasonable doubt standard, it should be the highest standard of proof that we have in any court system, I believe, in the world. But in terms of the reason for its existence, the reason for its continued existence, and the reason for our opposition here, I think to the heart of the matter here is that the additional human cost we're looking at is the cost to the victims here. And so while I understand there can be many testimony, like many people who come forward with testimony that would say that their non-unanimous verdict was a material injustice, I would argue that our ability to prove, even in a case before the First Circuit that we took a writ on a non-unanimous verdict where we had affidavits from the jurors saying we believed it was the higher case, The First Circuit there said it doesn't matter. It doesn't matter that we can see you had proof beyond a reasonable doubt. This is a different analysis. So I would say that the analysis before this committee today is different than the analysis that was before the voters in the prospective unanimous jury instrument that passed in 2018, as well as the analysis done by the Supreme Court of the United States that said this was not required.
Well, analysis do change. You cited the court, and I agree, analysis do change. At one point, the high court ruled separate but equal, and that was overturned. So the perspective can change, but the court has never once said, as a state, we should not go back and revisit this. The court has never said that we should not do what we're doing right now and make a public policy decision, as my colleague Senator Kusan said earlier, that we believe that it is more important for us to ensure that there is not a single soul who's been wrongfully convicted, that it is more important for us to do that than to not be willing to open this up to, yes, there will be look, we are all victimized anytime a case has to be reopened. That's easy for nobody. And this is in no way to disregard the victims, but I would suggest that the victims could be served by ensuring that if that person is retried and reconvicted, that we know that justice was served. We had victims to testify today, personal victims who came. What about their perspective? What about those victims? Why do we always disregard those victims?
And the response I would have to that is that the victims who are able to be present, the victims that are able to be identified again, I would ask the committee to think about the victims who are not. The people that are deceased, the people that, because it's a 30-year-old conviction and the witnesses are no longer available, that upsetting a valid conviction where it is functionally impossible to retry, I don't know that would be justice.
Is there not current Louisiana law that allows for the statements or testimony of deceased witnesses to be read into law or to be used in these sorts of tribunals? Is that nowhere in Louisiana law?
It would be dicey to do so.
Is it in law?
It is possible, but
it is in law.
I am telling you that it would rob the state of the moral authority of the case that we have. It would be reading to a jury, and I would argue that were I to come here and read statements from additional people, that would fall flat before you.
Do you not believe this is an issue that we must address?
I do. I know that we've had a number of conversations. I will commend you because I think in our conversations, the points that you make are always very clear, Senator. The points that I believe we are making to you, you are always receptive to. And if there's a path forward, we would love to continue that discussion. But the uniform release of 1,500 inmates, some of whom are, again, the worst of the worst. And just respectfully, we're going to keep the communication clear. But to say that this would be a uniform release of 1,500 individuals, we know that's just simply not the case. And I don't believe that's what anyone is asking for. I'm not asking for that, and I don't think anybody who came to testify here today is asking for that. Having done post-conviction relief work as an appellate attorney, I would say that it is dispositive. If you are able to establish it's non-unanimous, that is a release in a new trial.
Well, let me just kind of wrap up and talk about how the path forward. And we can agree to disagree on that. But you've acknowledged we need to do something about this. We clearly need to do something about this. And the question is, what do we do? Because this isn't going away. These advocates are not going away. And I hope the plan from the DA's Association isn't simply we're just going to wait them out until all these individuals who are locked up will ultimately pass away one day, and that's our way of resolving this. I will not accept that as long as I'm in this legislature. And I think from all the testimony that we've heard today, we owe it to ourselves to find a solution. And quite frankly, when I was having conversations before this session, looking at what the path forward was, I saw the bills that were brought in the House and those attempts. But someone said it earlier. I can't remember who it was. Because I know that one of my colleagues, one of my white male Republican colleagues on the House agrees with me on this. I'm not going to say his name, but I think he used the analogy that it's like a tumor that you have to cut it out. So we can try to play around with it and trim around the edges and do all these little fixes, Zach, but I don't think any of those are going to work. And I'm challenging the DA's Association to dig a little deeper, because I didn't see any pushback during the crime session about costs. About it, I didn't see any of that. And I just didn't see it. If we're going to be locking more folks up, that's going to require more prosecutorial manpower, more efforts, more resources from DAs, sheriffs, everybody, in order to, quote unquote, go after these criminals. I don't know how you do that without expending more costs. And I didn't hear any of the pushback. So I think that if we're talking about justice, if we're talking about moving our state forward, and really, as Dr. Bowie said so eloquently, he said, well, this is unfinished business. We can kick the can down the road and leave it up to the next set of legislators to deal with. Who's going to leave it up to the next set of legislators to deal with? Or we can deal with this and do the right thing. And I think we all know what the right thing is. So I'm asking, and I'm publicly asking the DA's Association to take a different path on this one.
And Senator, if I could respond to that,
Yes,
Mr.
sir.
Chairman, I know you're under a time constraint, is that in years past, there have been bipartisan supported bills that were attacked. I don't know where to go when you say continue to work when we do give our best effort. And it does not look like your bill, and I believe that's at heart a difference of opinion. But I am at a loss as to where to go once the bipartisan supported bills are attacked and flounder because of those attacks. I will continue to work with you. I will continue to work, and our membership has a commitment to work where we can find common ground on any bill. We will work toward that. But it's in the face of bipartisan supported bills being shot down that we struggle. So I thank you for your time, Senator.
Thank you.
Thank you, Senator.
I'll waive it. Thank you.
Okay.
Senators, Philip Terrell from Rapids DA. I'd like to say that my only concern are our victims. If I have a 30-year-old case, there, as Senator Duplessis says, there are provisions in the law where I can use transcripts of certain evidence that was from the first trial to try a 30-year-old case. I have 30-year-old murder cases, 30-year-old rape cases where the police officers are dead, where witnesses are dead or moved away that we can't locate. Some of those I will have to retry under if this statute goes into effect, if this bill is passed. If that happens, I have to face these victims and start these over again. So that puts,
I'd ask you, please hold down your commentary while we have witnesses speaking, or step out into the hallway, please.
The district attorney's position is we support our victims. That's all our position is. Our job is to look out for our victims who have these verdicts, and they have a contract with the justice system. We have delivered a verdict for them. The jury has delivered a verdict for them, and they've relied on that verdict for all these years, just like the murder victims that we had in the clemency proceedings. Thank y'all very much. Appreciate it. Thank you, Senator.
I certainly appreciate your testimony. I think that there continues to be a strong desire by everybody in the legislature that there be a path charted going forward. I also recognize the variety of sets of facts and information that you have about juries and about the decisions that were made and about kind of different categories that you may place some of those non-unanimous jury verdicts in, whether they were contemplating guilt or innocence or whether they were contemplating different levels of charges. I don't know what the direction of the committee is going to be today, but it's certainly my desire, and I think I probably speak for the majority of our committee, that we're really pressing upon you the desire to continue to work with Senator Duplessis to chart that path forward, because we have a lot of impacted people here today that we heard from, and it's certainly our desire that we see a better resolution that's more reflective of, I think, the desire of the state to move forward and move beyond what we would all agree and what we've agreed to do prospectively in regards to unanimous juries and non-unanimous juries. So with that concludes our opposition testimony. The board is clear, and I would turn it over to Senator Duplessis to potentially close on this bill. You may do from there, Senator Duplessis.
thank you, Chairman, for always being just wonderful in terms of how you manage very difficult subject matters. And this one has been particularly challenging, not just because of the amount of time that it has taken. I want to thank you for giving everybody the full opportunity to say what they needed to say. And you know, this one, I didn't think it was going to impact me the way that it has, quite honestly, after listening to all the testimony. One of the proudest moments that I've had as a member of this body goes back to 2018 when we voted to do the constitutional amendment. And it was proud. It was a proud moment because it gave me a sense of hope. And if there's anything that I've learned in my time on this earth is that everybody deserves hope, regardless of your past, regardless of what you've been through. Everybody deserves hope. And it gave me hope that this body could take a wrong and turn it into a right. But we haven't finished the job. And we cannot close the hope that an individual or individuals, whether it's 1,800 or 1,500 or whatever the number is, that if an individual was convicted by a non-unanimous jury, they know that at least 2 people on that jury did not agree with the other 10. And we cannot close off hope for those individuals, even if it's just the hope to go to another trial, to be convicted again. That's all we're asking for. That's all we're asking for. And I refuse to allow cost to be a reason as to why we cannot give them that hope. I care about the victims. That goes without saying. I hope that goes without saying. This is not an anti-victim measure. This is about doing what's right, period. And we are charged with that. The U.S. Supreme Court, the state Supreme Court, they put it on us. And we can't put it on anybody else. And I'm asking for us to continue to do what's right. We have that opportunity. Thank you.
Okay. Thank you, Senator Duplessis. The board is closed on the bill. What is the pleasure of the committee? All right. Senator Bowie moves that we report Senate Bill 383. Did we amend 383? Did we have an amendment, Senator Blood? No amendments? That we report Senate Bill 383 favorably. Is there an objection? All right. Senator Talbot objects. So Senator Bowie has made the motion to report Senate Bill 383 favorably, to which Senator Talbot has objected. A vote yes is to report it favorably. A vote no is to leave it in committee. Madam Secretary.
Senator Bowie? Yes. Yes. Senator Kuzan? No. No. Senator Duplessis?
Yes.
Yes. Senator Harris? Yes. Yes. Senator McMath? No. Senator Talbot? No. Senator Reese? No. 3 yeas and 4 nays.
3 yeas and 4 nays. Senate Bill 383 will remain in committee.